afternoon, everyone. Thank you for joining our online talk today, which will be starting shortly at 3 p.m. For those of you who are here early, thank you so much for waiting patiently. While you're waiting, we would like you to share a short video from our firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Applying to Commute Debt and Life Sentence under Malaysia's 2023 Criminal Law Reforms. My name is Megla Rajendran. I'm a People's in Chamber with Ma Weng Kwai Associates, and I'll be your moderator for today's sessions. Before we start today's talk, let me introduce the firm and what we do. Ma Weng Kwai Associates is a mid-sized law firm that was founded in 1985 by Dato' Ma Weng Kwai. Our able team today comprises of 33 lawyers and support team of 27. Dato' Ma is today a consultant with the firm following his retirement from Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small, medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relation team, and a department focused on servicing the needs of individuals and families. Our practice group indicates some of our focus areas, which are supported by our talents from both our corporate and dispute resolution teams. Today's talk is part of Ma Weng Kwai's online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with COVID-19 and MCO, we have been moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for our clients, potential clients, and in-house counsels. Before I continue, please be reminded, this talk does not constitute a legal advice. In the event you require specific legal advice to our matter, please contact us for complimentary legal consultation, details of which will be given at the end of this talk. Today, we have two speakers. Allow me to introduce the first speaker, Kirthika Padmanapan. She's an associate in our firm. She graduated in Bachelor's of Law, First Class Honours, and she was admitted to Malaysian Bar in January 2023. Her areas of practice include strata management, family and citizenship matters, employment law, and also criminal defense. Our next speaker is Ms. Agalyja J. Munusamy. She is a senior associate in our criminal, civil litigation, and family and matrimonial teams. She graduated with Bachelor's of Law with First Class Honour from Aberystwyth University. She was admitted in Malaysian Bar in 2014, and her areas of practice include criminal law, general litigation, debt recovery, and constitutional matter. The first two talk points of today's talk will be overview of sentencing reform and eligibility for sentence communication, which will be dealt by our first speaker, Ms. Kirthika. And for the last 2 points, namely commutation application process and the recent court decision, will be dealt by Ms. Agalyja. We will lastly conclude the talk with Q&A session. Hence, if you have any question, please don't forget to post it up in the chat box. We will address them at the end of the talk. Now I pass the floor to Ms. Kirthika.
Thank you, Meghala, for that speedy introduction. A very good afternoon to everyone present today, and thank you so much for taking your time to watch our talk today. As informed by Meghala, I will be dealing with the first two topics for today, the first of which is the overview of the sentencing reforms. I will now go into briefly the legislation. So the primary legislation governing the abolition of the mandatory death penalty is the aptly named Abolition of Mandatory Death Penalty Act 2023, or better known as Act 846, which came into effect on 4th of July 2023. It basically sought to abolish the mandatory death penalty, to vary the sentence of imprisonment of natural life and whipping, and to provide for matters connected by amending various statutory provisions in line with the government's policy to abolish the mandatory death penalty in all legislation. Previously, the mandatory death penalty did not allow judges to consider mitigating factors such as the circumstances in which the crime was committed, mitigating factors such as the individual's mental status and things like that, which could then show the circumstances of the offense were less serious or make the individual, in a sense, less culpable. Post-amendment, however, the court now has the discretion to decide whether or not to impose death penalty, or in the alternative, an imprisonment for a period not less than 30 years, but not exceeding 40 years. And in the event the individual is not sentenced to death, the individual shall also be punished with whipping of not less than 12 strokes. As you can see, with the new amendment, the courts now have the discretion to then choose between these alternative forms of punishment, and this would then allow them to take into consideration mitigating factors, including circumstances wherein the offense would then be deemed less serious in the eye of the court. In terms of provisions applicable, the provisions applicable, or rather the provisions for which the new amendments would be enforceable, the Penal Code, the Firearms Increased Penalties Act, and the Dangerous Drugs Act. As you will probably see on the screen, these offenses are numerous in nature, and let me just briefly go through the offenses under the Penal Code. So if you are in reference to sections 121 all the way through to section TO, these are offenses relating to terrorist acts or even acts against the Yang di-Pertuan Agong or the Yang di-Pertuan Negeri of the Negeri. So that would include the state rulers. So in these cases, the option of death penalty is still retained, but an alternative sentence, which I previously informed, that is the imprisonment of 30 to 40 years and 12 strokes of the whip, would then be implemented. So this then rather includes the discretion that I previously talked about. In terms of the Firearms Act, the firearms provisions, i.e. sections 3 and 3A, mostly in relation to the discharge of a firearm with intent to cause death, or essentially in situations wherein there are accomplices of those discharging firearms with the intent to cause death. So as you can see, these offenses would be deemed relatively serious. So in these situations, the death penalty option has actually been removed and substituted with an imprisonment for 30 to 40 years and the 12 strokes of the whip. So in contrast to the previous more serious offenses pertaining to terrorism and the offenses relating to offenses against the Yang di-Pertuan Agong, those offenses were deemed more serious than the Firearm Increased Penalties Act, which is why for the Firearm Increased Penalties Act, even the option of a death penalty has been removed. In contrast, for the offenses under the Penal Code, as stated on the slide, there the option of death penalty is still there. The amendment here is the removal of the mandatory death penalty. Now, in terms of the Dangerous Drugs Act, i.e. Section 39B, this offense relates to trafficking in dangerous drug, where the courier requirement is not met. So in this situation, essentially what would happen is it's distinguishable from other provisions under the Dangerous Drug Act, because in this situation, it would be the culpability and the offense, the particulars are slightly more serious, which is why the offense itself is called when the courier requirement is not met. So in this situation, given the seriousness of the crime, the option for death penalty is still retained, much like the offenses under the Penal Code. However, there is the introduction of the alternative sentence, that is the imprisonment and the 12 strokes of the whip. So much like the Penal Code, the offences under the Penal Code, the option for death penalty is still intact, but it's just that the amendment has then removed the mandatory nature of the punishment. In addition to the removal of the mandatory death penalty, another amendment that has come into force pursuant to Act 846 is the removal of life imprisonment. So what exactly does this mean? Imprisonment of life was previously defined under various bodies of legislation as the imprisonment for the duration of the natural life of the person sentenced, or alternatively, imprisonment until the death of the person on whom the sentence is imposed. So if you will see on the slide, I have laid out 3 separate acts, i.e. the Arms Act, the Penal Code, and the Firearms Increased Penalties Act. Under 3 of these legislation, imprisonment of life was previously defined with the definition stated on the slide, and that has since been amended. The definition of imprisonment for life has since been removed from these bodies of legislation. So this would be the interpretation section of Section 2 of the Arms Act, Section 130B, subsection 1 of the Penal Code, and Section 2, subsection 1 of the Firearms Increased Penalties Act. When we look at the provisions applicable wherein the imprisonment for life has been amended, we are talking about provisions relating to the Penal Code, the Firearms Act, the Arms Act, the Kidnapping Act, and the Strategic Trade Act. Similar to the previous provisions under the Penal Code, these provisions also relate to slightly less serious offences relating to the Yang di-Pertuan Agong or Yang di-Pertuan Negeri. So this would include waging or attempting to wage war or abetting the waging of war against the Yang di-Pertuan Agong, offences against the authority of the Yang di-Pertuan Agong, collecting arms, etc., with the intention of waging war against the Yang di-Pertuan Agong. And then in addition to those, there are also offences under sections 124K through to 125, which are also offences pertaining to terrorism, which include sabotage, espionage, and again, waging war with against any power in alliance with the Yang di-Pertuan Agong. So this would include countries deemed friends or alliances with Malaysia. In terms of the offences that have now been amended, would also include the Firearms Increased Penalties Act. So this would be sections 4, 5, and 7. Section 4 pertains to exhibiting a firearm in a manner likely to put any person in fear of death or hurt. So this is in contrast to the previous Section 3, where it was exhibiting a firearm in a manner which indeed did cause death or a serious harm. So similar to the Penal Code, you will notice that these offences are slightly less serious offences when compared to the previous offences for which mandatory death penalty was previously applicable. So Section 5 similarly is possession of a firearm when committing an offence, and Section 7 is the trafficking of firearms. Now, when we look at the Arms Act, the Sections 14 and 32 sub 1, these offences relate to the penalty for manufacturing without license and breach of conditions of license of a firearm, as well as the penalty for the use and possession of arms and the imitation of arms in certain cases. So these 2 offences pertain to the production for which life imprisonment was previously applicable. And then under the Kidnapping Act, we have Section 3, subsection 1, for which abduction, wrongful, which is basically the abduction, wrongful restraint, wrongful confinement for ransom. And it has now been basically the requirement for imprisonment of life has since been removed, similar to the offences under the Strategic Trade Act. So you might ask yourself what the offences under the Strategic Trade Act are. And it essentially relates to the shipment and transit of unlisted and strategic items, provision of technical assistance, together with brokering of strategic items. So these strategic items are defined under the Strategic Trade Act, for which the imprisonment of life has since been amended to the imprisonment with a minimum of 30 years, not exceeding 40 years. So just going back to what the imprisonment for life has since been amended to, in a lot of these provisions, the imprisonment for life provision has since been replaced with imprisonment for 30 to 40 years and a fine. In alternative situations, it has also been replaced imprisonment not exceeding 40 years and a fine. So it depends on the specific act and specific section, but in most of these provisions, it has since been replaced with imprisonment of either 30 to 40 years or imprisonment not exceeding 40 years, depending on the severity of the crime. I have spoken in length about the offences under which the abolition of the mandatory death penalty have been effected, together with the offences under which the imprisonment for life has since been replaced with either a 30 to 40 year imprisonment or an imprisonment not exceeding 40 years. I will now go and talk about the eligibility for sentence commutation. The legislation pertaining to the sentence commutation or the sentence reduction is the revision of the sentence and death and imprisonment for natural life Act 2023, commonly known as Act 847. And this came into force slightly after the Act 846, which came into force on 4th July. So Act 847 actually came into force only on 12th September 2023. And the entire purpose of Act 847 is essentially to provide the federal court with a temporary revisionary jurisdiction to review the sentence and imprisonment for natural life, which has been imposed on a convicted person, pursuant to the abolition of the mandatory death penalty and amendment to relevant provisions. So essentially what this act does is it allows the federal court to review the mandatory death penalty sentences or the imprisonment for life sentences, which have already been doled out and are currently being served by convicted persons. And essentially the federal court is now allowed to review the circumstances of the crime under which the crime was committed, and then based on that either remove the mandatory death penalty and substitute it with an imprisonment, or in cases where there is an imprisonment for natural life, to amend that and remove it and change it to either an imprisonment between 30 to 40 years or an imprisonment not exceeding 40 years. Which individuals would be likely or would be eligible for such revision in specific relation to the mandatory death penalty? We are currently looking at Section 2 of Act 847. So Section 2 of Act 847 essentially provides for the circumstances under which a sentence of death can be reviewed by the federal court. So as you can see, the provisions under which we discussed previously, that is the Penal Code, Arms Act, Firearms Act, and the Dangerous Drugs Act, as well as the Kidnapping Act. When looked at all these provisions, if there's any offense under which an individual has been convicted prior to the coming into operation of this act, so that would be prior to September 2023, this individual would then be eligible to make an application for a review of their sentence following the amendment of Act 846. Now, what is important to note here is that this person would be eligible regardless of whether an application for pardon under Article 42 has been rejected or not. Article 42 is essentially the provision under the Federal Constitution which allows either the Yang di-Pertuan Agong or the rulers of the Yang di-Pertua Negeri of a state to grant pardons, reprieves, and respites in respects of offences committed. So in terms of the federal territories of Kuala Lumpur, Labuan and Putrajaya, this would be the Yang di-Pertua Agong who grants the pardon, whereas in terms of states, it would be the ruler or the Yang di-Pertua Negeri of the respective state. So regardless of whether an application has been made for a pardon and that pardon has been rejected, you can still apply, an individual would still be eligible to apply for the review of his sentence of mandatory death penalty, provided that conviction was given before the coming into of this act. And another point to note is, in conducting this review, the federal court is not allowed to review the conviction of any person who is sentenced to death, which means, essentially, if a lower court has found an individual guilty of an offence which is punishable by mandatory death, the federal court cannot essentially overturn that finding of guilt and essentially not find the individual not guilty. So the scope of the federal court power is essentially just in terms of reviewing the sentence itself and not the plea. Section 3 of Act 847 further provides the requirements under which an application would be eligible. As you can see here, any person who is sentenced to death may make an application in writing within 90 days from the date of coming into operation of this act. If you calculate 90 days from 12th September, the time limit would have been 11th December 2023. However, there is a provision under Section 3 sub 3, which allows for the extension of the time specified under subsection 1, if the federal court considers that there are good reasons for doing so. Now, unfortunately, these good reasons for doing so hasn't exactly been defined, nor have there been any reported cases on what exactly this good reason under Act 847 would be. But perhaps what an individual may do is, obviously, in their application, state their reasons for the delay and try to make an application as soon as possible for the consideration of the federal court. Now, when we look at the revisionary jurisdiction of the federal court for the imprisonment of natural life, this is governed by Section 4 of Act 847. Similar to Section 2 of Act 847, it lays down the provision or the power of the federal court to review the sentence of imprisonment for life, provided that the person has been convicted prior to coming into force of this act. And this power of the federal court is given notwithstanding that a pardon has been given. Pardon has been rejected pursuant to Article 42, as discussed previously. And this would include an individual who has exhausted all other judicial proceedings. So this would be by way of appeals either to the High Court of Appeal or Federal Court. So this would essentially be an additional application for the Federal Court to review the term of the sentence of the imprisonment for natural life. So similar to the Section 2, the review here would only be for the term of the sentence of the imprisonment for natural life, and it would not be in respect of the actual conviction itself. So essentially in this case, upon reviewing the application, the federal court will then substitute the sentence of imprisonment of natural life with imprisonment of a term not less than 30 years, but not exceeding 40 years. Essentially, it's important to note that in this, it has then defined imprisonment for natural life as imprisonment until the death of the person of whom the sentence is imposed. So this is again the same definition that I referred to earlier, which has since been removed from numerous bodies, including the Arms Act, Firearms Act, and the Penal Code. So similar to Section 3 of Act 847, the application process for review of imprisonment of natural life would also have to be made within 90 days from the coming into operation of Act 847, which, as informed, was December 2023. However, there is a similar saving provision wherein the federal court may extend the time specified if it considers that there is a good reason for doing so. Similar to the provision for mandatory death penalty, that this good reason has not really been expanded upon by courts as yet. However, as informed, similar to the previous provision, the applicant would need to make an application and inform the court in writing of the reasons for which they are applying for an extension of time, and that application should be made as speedily as possible. Now, that concludes my section of the talk today. I will now be handing over to Agalyja to talk about the latter 2 points of the talk point for today, and starting off with the commutation application process.
Thank you everyone for staying with us and for joining us on the talk this evening. And thank you, Megla, for your introduction earlier, and my colleague Kirthika for her overview of the law reforms earlier presented. So I will be running you through the commutation application process itself and the recent court decisions that has been reported so far. So the application for the commutation itself, one should note that it must be made by the Prisons Department. So the applications will not involve lawyers as yet unless it's made by the Prisons Department. So how does the Prisons Department carry out these applications is that they have to file in a notice of motion supported with an affidavit in support of the commutation of their sentence. And this affidavit in support obviously has to be affirmed by the prisoners themselves who are applying for this commutation process and the review. These commutation procedures are either made under Section 3 or Section 5 of Act 847, as Kirthika has explained earlier. And the notice of motion itself must clearly state the grounds for the application being made. The Prisons Board can either submit these applications manually by sending a hard copy to the court and having it e-filed in court, or they can do it by way of e-filing via the EFS court system. Okay, a prisoner can then appoint their own lawyer or have one appointed by the court in case of death sentence, or be represented by a lawyer from the National Legal Aid Foundation, YBGK, in cases of natural life imprisonment to submit the applications. For prisoners who are applying from Sabah Sarawak, they will have to rely on their respective state lawyers to make the application. As for foreign prisoners who we find quite often are sentenced for either death or drug-related offences, the Prisons Department must have a discussion with the prisoners' embassies and consulates in Malaysia to carry out the applications on their behalf. What may, you ask, the outcome of the revision application? The federal court is currently cloaked with the exclusive jurisdiction to hear the revision matters pursuant to Act 847. And upon hearing the revision application and the submissions that were filed by the lawyers representing them, the federal court may either uphold or affirm the original sentence that has been passed, or they may substitute the sentences. And I'll give you here several examples of how these revision applications can change someone's sentencing that was originally given to them. So it could be either, as Kirthika has mentioned, Section 1(2)(a) of the Penal Code to 130 of the Penal Code are in relation to terrorism offences or offences against the YDPA or state rulers. So these sentences previously were mandatory death sentence, and they can now commute the mandatory death sentence to imprisonment for not less than 30 years, but not exceeding 40 years, and also whipping for not less than 12 strokes. In cases of a murder case, you may ask, so from a mandatory death sentence, the sentence can be substituted to imprisonment for a term of not less than 30 years, but not exceeding 20 years. And if not sentenced to death, they shall also be punished with whipping not less than 12 strokes. This is pursuant to Section 302 of the Penal Code. Further examples that you may see on the screen is for Section 3 of the Firearms Penalties Act, from a mandatory death sentence to imprisonment of not less than 30 years, but not exceeding 40 years, and whipping not less than 12 strokes. Another example I would have here on the screen is for Section 10 of the Strategic Trade Act 2010. It might not sound very famous yet, but what Strategic Trades Act 2010 is all about is having or exporting, or as mentioned by Kirthika, in trade of weapons of mass destruction. So basically that is what Restricted Strategic Act is all about. And for Section 39B of the Dangerous Drug Act, which used to be the very famous one where you would find everyone, or at least most foreigners, would be sentenced to death, but the death sentence has now been substituted, could be substituted with imprisonment for life. And if he is not sentenced to death, then he shall be punished with whipping of not less than 15 strokes to 12 strokes. So one might say that whipping is not a strong deterrent, but then if you were to find out how whipping will actually be carried out, then you will know that it's no less harsh than any other punishment that you can find. It has been stated that one whipping of the stroke can lead to your skin tearing. Two whipping may lead to someone being impotent, and there are so many other side effects of having whipping as a sentence imposed on a prisoner. Let me move on to the recent court decisions that we have found after the amendments have come into place. As of 16 November 2023, there has been 1,020 prisoners who are on death row and imprisonment for life who have filed their revision to the federal court. What that means is currently every prisoner who is on the death row and in imprisonment for life have submitted their applications for review by federal court. So earlier Kirthika was talking about how does the court determine the extension of time. So I would say that there's no longer a need for anyone to apply for any extension of time, since as of November 2023, everyone has submitted their review applications. And since the amendment have come into force, the federal court in November 2023, in a landmark decision, have revised the sentencing of one Mr. Teh Hock Leong, who has been on the death row for the longest time, currently serving 24 years since his arrest in 1999 for a drug-related offense. So after the court had commuted Teh's death sentence, his sentence was lowered to 30 years and then further reduced to 20 years for good behavior. It was reported in the news that Mr. Teh has actually gone home and he's out of prison and he's back with his family at the moment. So this revision was heard by the Chief Justice, the Chief Judge of Malaya, Tan Sri Muhammad Zabidin Muhammadiyah, and Federal Court Judge, Dato' Nordin Hassan. In January 2024, the Federal Court rejected a commutation application for the first time since the revisions began. So the Court of Appeal President Tan Sri Abang Iskandar Abang Hashim, who chaired the panel, dismissed one Junaidi Bambang's application after ruling that the circumstances of the case did not warrant the court to exercise its discretion under the new amendment to the law to substitute the death sentence to life imprisonment. This panel was also chaired by Dato' Mary Lim Tiam Swan and Dato' Abu Bakar Jais. So Junaidi was sentenced to death for the murder of his 3 daughters. A little bit of background on his case will be found on the next slide. So Junaidi is currently 67 years old and he was found guilty and sentenced to death by the High Court in 2005 for killing his 3 daughters, 2-year-old Julaika, 9-year-old Julaiha, and 11-year-old Jurianti at their house in Pahang. So Junaidi was found lying in the kitchen with froth coming out of his mouth, while the 3 girls were found lying motionless in the living hall. So Junaidi's lawyer, Ms. Selvi Sandra Segren, asked the court to commute the death sentence to life imprisonment of 35 years, saying that her client was remorseful and hoped that the court would give him a chance to reform himself. She said that Junaidi has already been in prison for 22 years. Unfortunately, this was not accepted and the court had actually affirmed his original death sentence. Further, in January 2022, the federal court had allowed the appeal of former palm oil estate worker who beheaded his co-worker to get his skull as part of ritual to secure a winning lottery ticket. And they had commuted his sentence to 35 years in jail instead. The judge panel was comprised of Chief Justice Tengku Maimun Tuan Mat, and the other 2 judges were Dato' Harminder and Dato' Nordin Hassan. The Chief Justice ordered the 52-year-old man, I believe his name was Francis, to serve the sentence from 1994 from the date of his arrest. Francis had been behind bars for 30 years, and Francis was also found guilty and sentenced to death by the Temerloh High Court for killing a Bangladeshi worker, Ali Ahmed, in an oil palm plantation in Pahang. So Francis was found guilty and sentenced to death in 1996. And the facts of the case was that Francis committed the offense on the advice of a bomo as a ritual. So he used a rotten cane to clobber Ali Ahmed's head until he was unconscious. before decapitating him. I'm sorry if all this sounds quite serious for those who are unaware of these kind of offenses being committed. It could be quite unsettling, but I'm sorry I have to go through these decisions just to make a point towards the end. And in February 2024, 7 prisoners in Sabah had their death sentence commuted, including a man who murdered his own parents over money. Certain prisoners, Muhammad Khalid Safruddin and Abdul Samit, had their death sentence for murder substituted to 35 years imprisonment from their date of arrest and 12 strokes of the cane. Muhammad Faris, Muhammad Din, and Edmund had their death sentence for drug trafficking substituted to 30 years. No whipping was imposed due to their age. In Malaysia, certain groups of people are exempted from whipping, and these include pregnant women, men over the age of 50, and juveniles under 21 years old. They have all been exempted from whipping. So in this case, those who were exempted from whipping were over 50 years old. So the federal court panel was chaired by Chief Justice, once again, Chief Judge of Sabah and Sarawak Tan Sri Dato Abdul Rahman Sebli, and Federal Court Judge Dato Abu Bakar Jais. Recently, a month ago, it was reported that 54 prisoners had their death sentence commuted and was replaced with imprisonment between 30 to 38 years. The Federal Court panel, once again chaired by the Chief Justice, the President of Court of Appeal, Tan Sri Abang Iskandar, and Dato Nordin Hassan. These prisoners were previously convicted of murder and drug-related cases. For the drug cases, each of them was sentenced to 30 years in prison, while the sentences for murder cases ranged between 35 to 38 years. So you may ask, what are the impacts of these recent court decisions? It has been reported by Amnesty International that they have been able to record between 4 July 2023 to 4th of January 2024, it has pointed to a significant reduction in overall use of the death penalty by Malaysian courts. So what this means is, now that the judges have a discretion to either sentence to death or imprisonment, it has been shown that the courts are more inclined to prefer imprisonment sentence rather than a death sentence. Amnesty International also reviewed the decisions related to cases involving 139 individuals so far, which was recorded between the dates 4th July 2023 and 4th of January 2024. Of this total 139 individuals, 42 people had their charges amended to a lesser charge, to a lesser offense, or were acquitted by the High Court or on appeal. In the remaining 97 cases, the defendants who were convicted of capital crime. 26 cases resulted in the death penalty being imposed or upheld, and a remarkable 71 cases in the alternative punishment to death penalty being imposed at the High Court or through commutation or appeal. These figures show that through the ordinary court process, the death penalty actually remained the preferred sentence for 26 out of the 70 cases. Discretion appeared to be embraced in favor of non-death penalty sentences, proportionally more by appellate courts. What they're trying to say is that even if the High Court, just so that all of you are aware, that only the High Court and above can impose a death sentence. So whatever cases that are sentenced to death have been sentenced in the High Court, and when it goes on appeal to the Court of Appeal or Federal Court, it is shown that there has been more favorable appellate outcome in these cases since the amendment has come in. So the death penalty was imposed in an alarming 44 of recorded cases before the High Court, whereas the percentage, as I mentioned earlier, was reduced to 21 to 25% in the Court of Appeal or the Federal Court. Significantly, the offense of murder correlated to a higher number of cases where the death penalty was imposed or upheld. So that means 18 out of 26 cases which was related to murder offenses, 18 out of them were equally sentenced to death. Amnesty International also recorded that 31% of all cases in which the death penalty was imposed or upheld between 4th of July last year to 4th of January this year related to this offense. The majority of recorded drug-related sentences were imposed by High Court. That brings us to the end of our discussion today. If you have any questions for us, we'd like to take some questions from the floor.
Thank you, Kirthika and Agalyja, for your insights on applying to commute death and life sentences under Malaysian 2023 criminal law reforms. So, as Agalyja said, let's move on to our Q&A sessions for today. It looks like there are a few questions from audience. The first question is, do you think Junaidi Bambang would have had his sentence commuted had he had been heard by a different panel? I think Agalyja can answer this.
Yeah, I'll take that, Megha. Thank you so much. This is a controversial one because, as I mentioned during our talk earlier, this is the only case so far that has where the federal court has upheld the original sentence, but without knowing the grounds and the reasoning behind the decision of the panel not to commute his sentence, it would be very difficult for us to comment further. It was also a unanimous decision to reject his commutation application. So we believe that there must have been good and cogent reasons and grounds for the federal court to affirm the original sentence for Junaidi.
Thank you, Agalyja, for your answer. And we have a second question. I think Kirthika will take this. Is there still a mandatory death sentence for drug-related offences?
Yeah, thank you, Meghala. So in 2018, the Dangerous Drugs Act was amended so as to do away with the mandatory death sentence, and it was amended to include death or imprisonment and whipping to not less than 15 strokes. So since the amendment that is Act 846 and 847, this has been maintained with a reduction in whipping of sentence being not less than 12 strokes. So from not less than 15 strokes, it has gone down to not less than 12 strokes.
You can take one more question. I think, can you answer this? Do you think that the crime rates will increase with the abolition of mandatory death penalty?
Okay, we do not think that crime rates, especially those involving serious crimes, will go up per se, just because the mandatory death penalty has been abolished. It must be noted that the death penalty has not actually been abolished. The only difference now is that the judges do have the discretion to choose between the death penalty or any other types of sentencing. However, during the parliamentary debates, the Deputy Minister for Law, YB Ram Karpal Singh, did say that statistically having a mandatory death sentence did not produce a marked reduction in these crimes. Therefore, I think it's necessary for the government to look into a more holistic approach for reforms and rehabilitation of the prisoners who commit serious crimes.
Thank you, Agalyja. Before we conclude, I have a few announcements to make. Please join us on our next upcoming talk, which will take place on 12 June 2024 on Navigating Medical Negligence Claims, a Guide for Families and Deceased Patients. Secondly, please also fill up our feedback form and tell us what are your thoughts on our talk. The link will be given in the chat box below. Please also do follow us on our social media. We are on YouTube, Twitter, Instagram, and LinkedIn, and also on Facebook. Lastly, if you would like to speak to one of our lawyers, we offer a 30 minutes complimentary consultation over the telephone or video conference. Please fill up the form. You can find it in our website, or the link will be also posted in our chat box below. To our guests, thank you for joining us today. We hope you have found today's session informative and useful. And thank you, everyone. We hopefully see you in our next upcoming talk.